name's Aubrey Palanca. So I've never done a case like this, or I've never done a presentation like this. So I don't really know what you're expecting, and I don't know, nobody else has gone, so I'm in like the first group of people. So yeah, I don't know what you're expecting, so I'm just going to do my best. I'm not sure how long this is supposed to be. I don't always get to make it online every week because I'm working, and so yeah, this was a little hard to do, but yeah, so I'm just going to do my best. Okay, so I had a case called Stokes vs. Bally's Pac West, and it's a slip and fall case, and it was filed in September of 2002, but decided in April of 2003. So what happened was the plaintiff, his name was Michael Stokes, he signed up for this gym called Bally's, and it's like a health center gym, and so he signed up to be a part of it. And so when he filled out the paperwork, there was a bunch of information and like release forms and liability statements and all that kind of stuff that's on paperwork when you fill it out. And so you had to do a bunch of signatures. And so like a few months after he signed up and like literally signed it, he slipped and fell on a round metallic plate placed in a wooden floor at the club while playing basketball. And he ended up injuring his shoulder and his knee. And so Stokes decided to sue the health club. He said that the health club's negligence caused him serious, painful, and permanent injuries. So Bally's Health Club moved for summary judgment, but the trial court denied. So the court decided to grant discretionary review of the decision. They also granted the health club permission to renew its summary judgment motion in the trial court in order to allow the court to consider this court's then recent decision in Chevalier, which is another court case. Stokes said that the health club owed him a duty. That's why he was basically suing them. So what the court did was that they looked at previous court cases that were in similar situations or had similar situations to this case. So a few of them were the Chevalier, I think that's how you say it, I'm not really sure. And then there was Baker and Hewitt versus Miller. And in these cases, the release was not hidden within part of a larger agreement. It was clearly labeled liability and release form and promise not to sue. So the court had stated from Chevalier that a person who signs an agreement and doesn't read it is bound by its terms. It doesn't matter if they didn't read what they signed, they're responsible for it. They were supposed to read it. If they didn't do it, that's their fault. The court also looked at other cases, including Hewitt and Conrad versus 4-point promotions or 4-star promotions. In each of these cases, the waiver and release form was in a separate document, not a separate provision in one document. So they looked at the types of cases they looked at were, the same type of case, but they had different responses. So in this case was most similar to the Chevalier because the language they found was conspicuous and it was enforceable and wasn't hidden or anything like in other court cases that they had. So the court looked Stokes ended up admitting that he didn't maybe read what he was supposed to sign. Like, maybe he didn't actually read it when he was supposed to. So, because before he signed, it says, "You acknowledge that you have carefully read this waiver and release and fully understand that it is a release of liability. You are waiving any right that you may have to bring a legal action to assert a claim against us for our negligence." So basically, Stokes was responsible for anything that happened to him when at the club because he had signed this paper, this liability waiver. And the health club wasn't responsible because he signed the paperwork. So I don't know why he even tried suing them, because he wasn't going to win anyways, but he tried. So then, the language at issue in this case was conspicuous and enforceable, and it was not unwillingly signed. He did know what he was signing. He was not forced, he was not hidden, it wasn't confusing to find. He knew what he was doing. It was his problem, he didn't read it, or whatever his problem was. In the end, Bally's Health Club owes no duty to Stokes for his injuries. The court concluded that summary judgment is in favor of Bally's is required. In the end, the court reversed both summary judgment orders and direct entry of summary judgment in favor of Bally's Health Club on remand. This case was a significant case because it is an excellent example of the value of liability waivers against liability for negligence in the recreation for sport setting. So it seemed like, to me, when I read this case, it was kind of like a common sense type of thing. Like, of course, whoever got hurt, it's their fault for getting hurt. They signed a waiver. That's what the liability waivers are for. And of course it's his fault. It's not the club's fault. But I think that there's probably lots of cases like this and that have happened since this case, because people want to sue because maybe they don't have the money, or maybe they want to make money. Whatever their reason for suing is, yeah, I don't know. It seems like such common sense, but I don't know. I guess this must happen often. The issues addressed by the court. The most important issue that was addressed by the court was, for the slip and fall case, is the language in the waiver and liability form. Was it conspicuous, there we go, or enforceable? So was it easily accessible to see, to read for whoever's signing it? That's what the court was looking at, and that's why they looked at previous court cases and on both sides, both ends, to see what the decisions were made and because of why. So they used these other court cases for this reason, and that's what they were focused on, and that's what they were looking for. The rule of law is what the court applies to determine the substantive rights of the parties. In this case, the rule of law derives from prior holdings to similar cases, common law. That's exactly what I just said. So in the end, because of the previous cases, because of they looked into what the liability waiver actually said, they ruled that Stokes Health Club is not responsible for him and for Stokes, and he is responsible for himself. He signed it. He's responsible. And the language is what they looked at to see if the language was enforceable or not. And I thought that this case was very interesting. I've never read a court case before because I've never taken a class like this. So it's all very new and very kind of difficult to understand. Actually, it's really hard for me because I've never had anything like this and never had to take a class like this. I don't know much about the law, but now I guess I know a lot more. So yeah, I hope I covered everything I needed to, and I hope you enjoyed it and learned a lot. It was interesting, even though it took me forever to find on LexisNexis. Was it LexisNexis? Whatever it's called. It took me so long to find on there, but it took me a few days, but I found it, and I'm glad that I got to read it and understand. I hope I understood it right, and yeah, so thank you for watching.